Motion bring for listing of an IFO motion tomorrow, Lordship. Matter pertains to non-registration of FIR by police, Lordship. Police is not registering FIR, Lordship.
No, witness.
Some
Already,
urgent
no urgency.
accused is threatening the petitioner, Lordship,
Witness.
of the Lordship.
For withdrawal, item 35.
May
No,
please,
I'll put it.
may please, your Lordship.
Yes.
Lordship, this writ petition was filed challenging, Lordship, the disallowance of transitional and input credit, Lordship.
Hmm.
By the order in appeal and the order in original, Lordship, the
Hmm.
authorities has imposed certain cost and penalty also, Lordship.
Hmm.
Now, Lordship, in the meantime, Lordship, a amnesty scheme has been declared, Lordship. It is at the page number 12 of the IA, Lordship. Page 12 of the IA, Lordship.
Hmm.
Now, if Lordship comes to page 14, clause 3.1.6,
Yes.
may I read, Lordship?
Hmm.
Where an appeal under section 107 or section 112 has been filed by the taxpayer against an order referred in clause B and C, B or clause C of the subsection 1 of section 128A, or where a writ petition has been filed by a taxpayer against a notice, statement, or order referred to in clause A or B or C of the subsection 1 of section 128A, the taxpayer is required to withdraw the same before filing an application of waiver of interest or penalty or both, and enclose the order of withdrawal of such appeal or writ petition is along with the application filed in from such and such as the case may be.
Okay.
That's why we have wait for withdrawal of the writ petition. That's it.
Okay, I heard. Who is Mr. Kyle?
Copy was served, Lordship. Probably
Okay,
some
I'll
other court.
I have to record his name, just his presence.
Lordship.
Miss Mormon, can you make a call to Mr. Kyle? Then counsel for the applicant. Read petitioner. And Mr. S.C. Gallol Giro, and it standing counsel. Central Goods and Services Act. For the opposite party number 124. That's respondents. And Mr. Kaur, you can record Mr. Bigo's name. He is withdrawing it.
Yes.
Mr. B. Gogoi, Learned, Standing Counsel, Finance and Taxation Department. For the opposite party, that's respond number 5. To stop. The applicant hearing as the repetition has preferred the connected repetition, WAC number 5476/2024 to assail an order in original dated 6/2/2023. 6/2/2023. Passed by the adjudicating authority pursuant to a demand come show cause notice dated 9/2/2022. Issued under subsection 1 of section 74 of the Central Goods and Services Tax Act comma, 2017, right? This 74 is also covered.
Yes, Lord. Seventy-three, Lord.
Your case is 74, that is why. But an order is usually issued under such an order is valid. Pursuant to a demand come show cause notice. It is so and so. And an order in appeal dated 14/11/2023. Full stop. The applicant writ petitioner has preferred the instant application for withdrawal of the writ petition WPC number 5476/2024 with a leave to file an application under section 128A of the CGST Act for waiver of interest or penalty or both. Full stop. Mr. Kapil, learned counsel for the applicant, writ petitioner, has referred to a circular of the Central Board of Indirect Taxes and Customs, Department of Revenue, Ministry of Finance, Government of India, dated circular numbers, page 12, dated 15/10/2024. More particularly, clause 3.21.6, which reaches under paragraph page 14 of our set, 3.6. As the last date for filing an application under section 1 under the scheme framed under section 128A of the CGST Act is 31/3/2025. The petitioner wants to withdraw the writ petition to file an application before the competent authority seeking waiver of interest or penalty or both on or before 31/5/2025. 31/3/2025. And for the state purpose, for full stop. Mr. K. Jain, representing Swenson. Having regard to the submission made by the learned counsel for the applicant, writ petitioner for withdrawal of the connected writ petition for the purpose of filing an application under section 128A of the CGST Act on or before 31/3/2025, and instead interlocutory application is allowed. Full stop. Para, I draw repetition. Heard Mr. DJ Kapil, learning counsel for a repetitioner. SC Cal of K. Jain, land counsel representing Mr. SC Cal, and standing counsel CGST for harassment number 2, 3, and 4. And Mr. Gogoi, and standing counsel Financial Taxation Department for the harassment number 5. Full stop. In view of the order passed today in I number so and so, the writ petition is accordingly disposed of.
Highly.
Daily list for motion, item number 1.
Yes. Received. Okay, we'll take up on next Thursday. Yeah, it's not very good to do. Heart, Mr. You go through it. You may have to prepare appeal, maybe. P.K. Gogoi, learning counsel for the petition, MSP R. Mohanto, and standing counsel, Revenue and Disaster Management Department for harassment number 1 and 2, and Ms. M. Borman, and Junior Government Advocate Assam for harassment number 3, 4, and 5. MS Borman has submitted that his instructions have been received in deference to the order dated 9/3/2025 and has placed the instruction before the court. Also, let the case be listed on next Thursday.
3rd April.
Ah.
3rd April.
The instructions placed by MS Borman is to be kept with the case record. Similarly, other one, item number 2. Same.
Highly apologize. For hearing, item 3 to 34.
SOP consult. Sure, yeah, before you start, I'll just have some queries. I'll put it so that I will not interrupt. Representation, yes, SOP can deal with or 15th. SOP. No, I can't. You raise the point of maintainability
Lordship,
in connection with one writ petition.
Lordship, filed by NQ.
Yes. I have found there are 2 more in this batch.
Lord.
So what is your submission on that?
My
Right.
submission will be same for the other two also.
Mr. Talukdar is a petitioner perhaps.
Yes.
In the other two petitions also. That is one. Secondly, in the SOP, this Election Commission of India notification is the
Basis.
guiding thing. And this has been, I have gone through what is the implication of it. I have gone through this document.
Lordship.
This one, the Election Commission of India. Now, I find that Representation of People Act, as per Section 8, because I was not familiar with all this, so I also read
Same is the case with you also. Lordship.
8 Representation of People Act 1950. 1950, Section 8A, subsection 5, subclause E. 8A, 5,
E.
small e. It says, if this kind of notification after a delimitation process of LACs and parliamentary constituencies, it has the force of law. And the constitution bans in Meghras Kothari, which has been referred to, it says it has, though it is not passed by parliament, it is passed by delimitation commission or election commission of India, it has the force of law.
Lordship.
Then going further, I have seen from this document and the notification, all these LACs have been
Demarcated.
demarcated. And going further into it in LACs, I have seen many Gram Panchayats are part like that. So from other clauses are also flowing out of clause 4 Roman 1. All are saying after LAC delimitation.
Lordship.
This word and this LAC delimitation, if the ECI notification, he will make it clear whether it is gazetted. If it is gazetted, I think it is gazetted. Then it has the force of law as
Yes.
per the constitution bans.
Yes.
So what is the implication of it in the Assam Panchayat Act?
Yes.
This has also to be addressed because everything is structured.
Yes.
If I have found correctly in all the writ petitions, under section 5 within bracket 1 and section 3 capital A perhaps,
Be.
and section 3A, it says because ultimately I have found all the notifications dated 15/10/2024 have also been challenged. And that
15.
10,
That notification. Yes.
subsequent notification,
Yes.
and that because 3A says district government shall constitute in every district a district delimitation commission. That is okay. Next part, to decide the size of Gram Panchayat, Anchalik Panchayat and Jila Parishad.
Lordship.
Whether power has been given to the district delimitation commission to decide. This is one part I like to have an answer, because ultimately 15/2/2024 has been issued by the state government. And where is the power, where from the state government has derived the power? And in the SOP itself, at the end,
9.
Jila Parishad constituencies have been already decided on 3/8/2024. I have seen a table, this table, this one.
Yes.
Already Zilla Parishad constituencies have been decided. And Assam Panchayat Act says, or the SOP also says, Anchalik Panchayat, because it is a three-tier, so it is a pyramidal structure. Zilla Parishad, then Anchalik Panchayat, and Gram Panchayat. Ultimately, challenge is to the Gram Panchayat. But I could understand. Anchalik Panchayat is co-terminus with development block. That has been also tinkered with by the Election Commission of India, and Gram Panchayats are also tinkered. If you have the notification, so that's this one, Election Commission
Yes.
11.8.
11A.
Okay. And because 2-3 petitions are from Sonai, just we'll have a look. First petition, it says LACs have been so and so, like that. If you see Sonai, that question was also put by me to Mr. Barbara also. See the first 119 Sonai.
Yes, Lordship.
First is Sonai Municipal Board. That is that will be out from Gram Panchayats,
Yes.
part 9. Solai MB means Municipal Board. Banskanti Development Block part. Block has been also tinkered with. Then if you go on, Banskanti Development Block excluding Palarbon GP, they have segregated. Dologram GP. Then next one, Bodri Sonpur GP part. They have tinkered. Election Commission of India has separated the Gram Panchayat also.
In their notification.
And it has the force of law.
Yes.
And constitutional bench has said that it has the force of law. So these aspects
Yes.
now.
So far as that part is concerned, if we look at the main objective of the Election Commission notification, that is for the purpose of LSC or the parliamentary constituency, not for the others. In doing that, there can be some reference to the Gram Panchayat, but their limitation exercise was limited to those particular segments, that is the LSC, that Legislative Assembly constituency, or the parliamentary constituency. It has nothing to do. Maybe while doing that, some areas has to be indicated, and that area will fall under some Gram Panchayat or election, Jilla Parishad or Anchalik Panchayat.
Yes.
But anyway, I will address to that. And regarding this Sonai, Lordship,
No, all the things I have seen everywhere. Everywhere I have seen.
That will make the whole Panchayat Act redundant. The delimitation exercise as contemplated under the Panchayat Act vis-a-vis the Election Commission's Act of 1951 and 50, and the notification issued by election, there will be total conflict. That means all this exercise, which is contemplated under the exercise of the Panchayat Act, Lordship, that will, everything will become redundant and meaningless. That means the Election Commission, whatever they gives under the LSA or the parliamentary, that we will have to follow. That is not the idea. We have to read it conjointly.
Conjointly, that is why.
And to make it workable, functioning. That is what we have to appreciate, Lordship. It is not that there is a conflict.
No, I am not saying about
Yes.
conflict.
Yeah. If suppose the Election Commission conducts the delimitation exercise now, in their notification, this description of the area will be different. Considering the fresh delimitation exercise. Suppose another delimitation exercise is contemplated maybe on 26 onwards. I do not know when Assam will get it done, but for the rest of the country, they have done it about 15-20 years ago. Now it is pending. So in the meantime, lot of Gram Panchayats and other Panchayati Raj institutions, there is a drastic change of the area. So this will come into the new delimitation exercise. But I will address to that in my appropriate time. Lordship. This query Lordship has raised, and but there as this was not-
Because going further into
Yes,
this
yes.
document, every development block also
Yes,
have been touched. And villages have also been touched.
absolutely.
Going further,
That is why.
that is why.
That is why one very important affidavit is required from our end. Why?
To,
This
to,
notification
to
of.
assimilate both the thing,
Absolutely,
that
otherwise
is what,
we cannot connect the dots. Because they are also.
because they
Lordship,
are in a different tangent.
Yes, they are in a different tangent. Our affidavit is in response to their affidavit.
That is, I have
But
found,
the complete picture Lordship is not getting.
not getting.
Why I am saying Lordship?
And
On
I have been,
15th
I have been
Indicate.
asking the council, but
the-
they are not responding.
I am responding to their Lordship, because when I have gone through in details, all these things have come into my mind. On 15/10/2024, the
Hmm.
notification was issued by government. Subsequent to there, on 11th of November 2024, the final notification was issued by the Delimitation Commission, where it has been mentioned about the final size of the Jilla Parishad, the Gaon Panchayat and the wards. And this exercise of doing the delimitation exercise of the Gaon Panchayat, which they are challenging in all their petitions, parallelly the ward, that 10 number of wards in each GP, that delimitation exercise was also undertaken. That is not put to challenge.
No, Koti is not aware also.
Even I was not here till 1 day ago. So these things have to be brought to the record, because I want this honorable court to pass a judgment, whatever way it goes, Lordship, but based on the correct facts. Those exercise, in my humble submission, the Election Commission will be the right authority to place it before this honorable court. Without those facts, because 6(2), if we let us come to the SOP now.
Hmm.
Any further query, Lordship, I have noted down.
Because in your affidavit, you have said that there is no categorization of districts.
That is one part.
That is one part.
To their response.
To their
But what
response.
about 6(2)? They have not raised 6(2).
Right. So you are saying impliedly that you are not following 5 within bracket 1. And the proviso.
The proviso part. The first part actually it has to be read together. That may and shall, and I have to get a composite view, and I have to make a further submission on the whole meaning of 5(1) along with the proviso. But that I will make my
Okay.
arguments at a later
Sure.
stage.
Yes.
So now, if Lordship is pleased to take the SOP page 32 of the writ petition. 5346.
Okay. I have the gazette with me.
Here, if Lordship is pleased to come to for delimitation of Gaon Panchayat, then you see that all these are okay. Now coming to serial number 9. The other day I did not make much submission on this, but
Serial number 9.
9. After delimitation of the Gaon Panchayat, the delimitation of Gaon Panchayat constituencies, example, 10 numbers of wards within the GP shall be done as per 6(2) of the Assam Panchayat Act 1994.
SOP.
It's the SOP itself.
Clause
4 Roman 9.
4 Roman 9. Yes.
That exercise is done. If Lordship is placed to take my affidavit, the addendum part. In addendum, Lordship will kindly come to page 113.
Yes.
Here, when the objections were called for or invited, Lordship will kindly come to the bullet point 3. I mean, there is no numbering, third bullet point and Roman 2. After publication of draft GP word, that is what I am trying to emphasize. Anchalik Panchayat and Jilla Parishad in the prescribed format, public hearing will be conducted at district level, which will be constituted LAC wise. So when we are asking for the objections, one part is that Gaon Panchayat part is there. But along with that, we are complying 6.2 also. What is 6.2 in the act? 6.2 says, may I just read it, Lordship? Constitution of Gaon Panchayat and election of president and vice president.
Yeah, concept. Acha. Yes, 6.2.
6.2, heading Constitution of Gaon Panchayat and election of president and vice president. I am coming to 2. For the convenience of election, the prescribed authority shall, in accordance with such rules as may be prescribed in this behalf by the government, divide the area of the Gaon Panchayat into 10 territorial constituencies and allot 1 seat to each constituency. So there will be 10. Basically, what they are saying, it is the words within the Gaon Panchayat. So this exercise of delimiting the Gaon Panchayat, parallelly, Lordship, the delimitation work of the 10 number of words, which is mandatorily should be there in each Gaon Panchayat, that was also carried. And therefore, after the government notification, the delimitation commission, if we come to the SOP, once more, the first part, Lordship, not the addendum.
Yes.
The delimitation commission will have to issue the notification. Yes. Huh? Roman 9. 9. Finalization of the delimitation and notification. The final delimitation process of Gaon Panchayat, Anshalik Panchayat, Jilla Parishad and notifications of the same by district delimitation commission is to be completed by 17 September 2024. So that is one part they have issued, then the government issued. And after doing everything,
It is by district delimitation commission.
district delimitation, that also I have found something. The final notification, then that was issued. For example, Lordship, one, this is there in one of the petitions which we are seeking dismissal, but I am getting extra copies, so I am not relying on the written petition, I am giving it. That's why an affidavit will be required. Word of the courts. I have lots of got it.
Yes.
11 November, in exercise of the power conferred under subsection 2 of section 6 of the Assam Panchayat Act, read with sub-rule so and so, in pursuance of government notification dated 15th October 2024, the following Gaon Panchayat constituencies ward under Gaon Panchayat of Badarpur, Chaitanya Nagar Anshalik Panchayat and Jilla Karimganj Jilla are hereby notified. Here Lordship will see serial number on top. Then next column is name of GP. Next is Gaon Panchayat constituencies, ward number, villages, landmark, etc. So everything is here given. If we look at serial number 1, Longai Ghat and Hajari Ghat, that is the GP. Ward number 01. Then this description is Umapati, that is the village, and including the households, description is also there. This is not put to challenge. This is the ultimate notification. Here reference is given to the government's notification of 15th October also.
What the 15 October,
15 October, which
October
is put to
have
challenge,
decided.
Lordship is saying that whether government has the authority or not. So that has not been raised. So definitely we'll examine whether government has the authority or not.
This is under section 5(2), 1510.
Is 5(2) and this is 6(2).
Yes, 6(2).
6(2).
Hmm.
So on those issues, Lordship, we will need some time to examine and put everything on affidavit, including this notification, because midway they have challenged. In fact, before the publication of the 15th October notification, also one writ petition was filed. Subsequently, they have filed. In the meantime, all these places throughout the state lordship, this 11 notification was issued. Except those effective writ petitions, nobody has brought to the notice of this honorable court, neither my learned friend lordship from the election commission. They have also not brought. Now they are disclosing all these facts to us. So as government, we have some limitations. So in any case, lordship must get the full picture, complete facts. So in our writ petition, I think 3 or 4, maybe more than 4 districts are involved. And on the query of lordship that whether the notification issued by election commission, they have given some description of the Gaon Panchayats and various other entities.
Because it is to be diligently followed, that is why.
Exactly, Lordship. If that is the case,
Not-
that this whole exercise, not only here, it is a pan-India ramification. This will have a big ramification. So we
Because-
have to examine.
Your
Yeah.
clause 4(1) says it is to be diligently followed. Election Commission.
Yes.
If there is no statement here in the affidavit that it is diligently followed, we cannot make roving inquiry.
Absolutely.
This Gaon, then wards, the villages, we cannot go into that.
But at the same time, that 11 notification lordship cannot ignore also.
Yes,
So.
so
let us
basically,
examine
because
what
the
exactly is
affidavit
the-
I have read, but
Yes, yes.
but could not
Only thing is that, Lordship,
find a total answer, Mr. Kumar.
that prima facie from common sense, Lordship.
Our first affidavit, your lordship, paragraph number 4, we have indicated.
But
Our first affidavit. Affidavit, file number 3010. Page number 10.
105.
because 4(1) says then that is silent, then next, the affidavit is silent, that you have followed 4(1) diligently.
So in paragraph 4, we have to make a reference, Lordship, about the
Wait.
first affidavit. We have filed 2 affidavits till
to
now.
Page,
Page 105.
Hmm.
Paragraph 4. At the outset, the present deponent begs to state that it has become imperative for the government of Assam to carry out the process of delimitation of Jilla Parishad, Ansarik Panchayat and Gaon Panchayat and reorganization of the development blocks in the state following the delimitation of legislative assembly constituencies of the state as per Election Commission of India's notification dated 11th August 2023. The delimitation of the Jilla Parishad, Ansarik Panchayat and Gaon Panchayat and reorganization of the development blocks involves redrawing the boundaries to ensure equitable representation and efficient governance. It is aimed to ensuring geographical contiguity and compactness of the area concerned, which will pave way for administrative efficiency, decentralization and electoral equity, better region-wise planning, and more equitable allocation of government funds, etc. in tune with the changing demographics and administrative need. The Honorable State Cabinet in its meeting held on 19/6/2024 decided to take up the process of delimitation of Gaon Panchayats, Anchalik Panchayat and Jilla Parishads. Accordingly, the government of Assam in PNRD issued notification on 3/8/2024 for SOP, Standard Operating Procedure for delimitation of Gaon Panchayats, Anchalik Panchayats and Jilla Parishad, wherein criteria are mentioned for systematic and efficient process of delimitation by district delimitation commissions in the state of Assam, that is DDC. So we have made a reference.
so because we cannot go into all these nitty-gritties.
Very.
There
And even the
is
registration
limitation for
officer
the
did not
court.
Brought all these facts.
There are limitations for the court. We only want to see that part 9 of the Constitution of India.
Exactly.
Then, since that Election Commission of India has done LAC and parliamentary constituency delimitation, which has the force of law, and you have said that you would definitely diligently refer to and follow all the clauses in clause 4. After LAC delimitation, you find a word. Then ultimately, whether the state government and the district delimitation commission, whether have done the exercise in conformity and without violation of the anything, section 5, section 6, corresponding rules. That is all we have to see. That's all. We are not going into villages. This village has gone to that village. This village has gone to. We are
And
not
so far as population.
investigating officer. And plus, there is a point raised on the basis of Article 243C.
That
This is
also-
all.
That also we have a proper reply, Lord.
That's all. But
What the parameters the Election Commission of India have taken. They have given some datas, like in Dima Hasao area,
Hmm.
the density of population is 38 persons per square kilometer. Vis-a-vis in Guwahati or in Kamrup, it is 1200 plus. So all those figures also were considered by the Election Commission.
yes, yes.
So those things also I have to like to place.
Because I have checked the data.
Yes, data is
I have
totally-
checked.
From 30
I
to
have checked
1200
the
plus.
population data of 2001 census.
Lordship, that we have to follow.
And that has to follow. And suppose I have seen LAC constituencies, how this Anchalik Panchayat, I think. If you see, I just tested one case. 64, section 64. I just tested one case,
Lordship.
just for purpose of my knowledge. 65,
Consider Jilla Parishad.
64.
Established
64 and
as-
65, right? 65, one, then proviso.
Lordship.
Provided that the government may by notification in the official gazette determine the territorial constituencies in the district, keeping in view the overall population of the district at a rate of 1 member for a population of not less than 30,000. And each territorial constituency shall elect 1 member to the Zilla Parishad through the direct election in the manner prescribed. Then I just tested from Election Commission. In Majuli, the population I have seen, and there is 4 constituencies. I have checked this Kasar. Accordingly, this proportion has been maintained by, it gets automatically percolated down due to ECI notification. And that has been followed. Here is a question of about district panchayats. They have not challenged ZPC and Anchalik Panchayat constituencies. But we have to come down from parliamentary to assembly to Zilla Parishad, then to Anchalik Panchayat, then
Gaon
Gaon
Panchayat.
Panchayat.
Then further word.
Ward.
A
That is
word.
the power. What are the exercise you have undertaken?
Lord.
That is to be. This village going to that Gaon Panchayat, I am not. I have straight away said.
So, what my
And if
submission-
there is any other mechanism, you can suggest.
Lordship. So one short affidavit I would like to place before this honor report. The sequence of events, date-wise in chronological. That will be convenient for the honorable report and for us also to place the case because there are some lot of missing links here.
Okay.
And on top of that, I have to examine whether the government has the authority to issue the notification of 15th October. That query is now coming from this honorable report. It was not raised by the other side.
No, I have.
Yes, and it's a very pertinent question, but they have not raised it.
No, 5
so-
to there is something. There is something
In
that,
Jilla Parishad by the government, it is written.
no, 5-2 is there. 5-2C, 5-2.
Yes, sir.
It is there. That is why I am asking. After consultation with Gaon Panchayat, I think there is no Gaon Panchayat.
Yes.
If it is already been established, there are Gaon Panchayat established. Right?
Lord.
You have to just do some State government may by similar notification at any time include within or exclude from. Now, if you see 1510, 1510, Anshalik Panchayat is also co-terminus with development block.
Lordship.
That has been already done, done by ECI. Now, name of the Gram Panchayat, name of villages here. State government has not done the ward thing because you have said ward is,
What we have done
you have done.
simultaneous.
On 1510, you have not done the wards.
Yes, here it is not there.
Only
Maybe
villages
11,
you have
11, We
included.
have the word.
Villages you have included that what are the village, what will be the villages within a particular Gram Panchayat.
Yes, Lordship.
If that power is available somewhere, that is what I am asking.
Lordship.
Because we have to see the law also, what has been laid down by the Supreme Court in many cases. So, if the state government has the power,
Only big issue is that election commission's notification indicates the minor details about the Gaon Panchayat up to that. Whether we can ignore that and continue with the.
or you have
delimitation
followed it.
We have to follow. As per whatever he said, that it has the force of law.
If you see Meghraj Kothari.
Yes, I'll look at it. But exactly that force of law, in what context we have to examine? Whether it is in the context of the LSC or the parliamentary constituency, or it will come to the other part.
Subsequently also it has been referred to
Yes.
in
that
case
is
of
why we
Panchayat
have-
and municipalities by Honorable Supreme.
I'll definitely
Right.
examine.
Right, that is why I am saying,
Otherwise, this,
because I cannot also go something beyond this.
yes. got it.
And whether anything is there in Assam Panchayat Act, like Election Commission, once it is done, has the force of law.
Then this whole section 3 onwards have no meaning if it is, we have to purely base it on the election commission's exercise regarding panchayat. Because the notification and all the judgments I will definitely examine, there must be, or maybe this will be a new area. Maybe this is a gray area. Maybe this point was never argued.
No,
before
no,
the Supreme Court.
no, I should not, no, it has been argued. It has been argued, that is why
No,
the,
Whether the election commission's description of the parliamentary.
that
procedure,
right.
Is this binding on the Gaon Panchayat or not?
That I
is-
don't know.
That will be the query.
Ah.
That will be the issue.
Because the very first line
Yes.
in the Election Commission of India, in pursuance of section 8A5E,
That is
Ah.
election commission.
and you have undertaken to follow it. That is why,
Lordship.
that is the only query and no other queries. If you have sailed by the notification, nothing more to examine.
Apparently there are changes. So far as Gaon Panchayat, Jilla Panchayat, all these things.
No, ECI has also done it.
ECI has done it from a different perspective.
Yes.
Our
And-
perspective is different.
So this line is diligently followed, whether that has been deviated later on. That is only to be seen, and state government has the power
Yes.
to issue notification 1510. And consequently, the district authority can bifurcate the wards. We don't have to examine villages and all. That's all, or that's the only limited issue. Nothing more, nothing less, that's all.
That affidavit will be required.
And 243C.
That I will address, Lordship. For that, Lordship, I have all the data from the election commission's notebook, handbook itself. So I will compile it, which is relevant for our purpose in that affidavit, Lordship.
Any other point?
I have lot of, because they have.
Yes, yes,
argued about-
please.
I-
We can continue. I have kept the whole day. I have no other case.
Otherwise, Lordship, that my argument.
If
is-
you,
I
yes,
need the basis, the
Ah.
foundations to make my argument, because they have argued on various points. One point is that we have violated 6(2).
Six.
What are the affidavit will be required?
6(2) or 5.
No, 6(2), they have said that section 3(6)(2) has not been complied before deciding the Gaon Panchayat into 10 territorial councils. So that for that, Lordship, I have to bring these facts. These are not pleaded case. During their arguments, they develop their arguments on various legal issues, but without having any proper
Right.
justification
No,
and
if-
proper factual foundation.
If something is not there, with a foundation, even for arguing a law point,
Got it.
the factual foundation must be there.
Absolutely.
If it is not there, May not go into. Will
It's
not
a basic
venture into.
Principle of judicial procedure.
Will not venture into.
If lordship says then I will not argue that point at all. Because my submission is very, but I'll have.
No, we don't have any affidavit except
Yes.
in two
Our
state affidavit.
That's why at one point of time, we wanted. to-
That is also a problem.
Because my instruction from my assisting counsels and colleagues lordship is that this honorable court wanted affidavit only on the point of what we are going to argue on the broader issues,
Legal issues.
legal issues.
Constitutional provision.
Yes,
Panchayati Raj provision.
Yes.
And if delimitation act comes or representation of people acts come and the rules
Lordship.
plus the SOP
yes,
and gazette notifications, that all.
absolutely correct lordship.
No village, this thing. That
But For
ex
that
village.
also, we have not, these two affidavit will not be sufficient because certain important events
Huh.
they were not highlighted in our affidavit.
Yes.
So if lordship allows us, then we'll give a complete affidavit where all these facts will be which are relevant, will be part of the record.
But they are saying it will be, but declaration will be made. something
Declaration
like-
will be made. Declaration will
So
not be
let us hear it, close it.
without the affidavit. I am ready. Otherwise, I am ready with that. These queries have come, that is why.
Ah.
Otherwise, I am ready. to-
Only legal points that is.
The legal points to legal.
Only
points.
that 243C has been kept in consideration. Only thing 233 points.
What is 243C? Let us see, lordship. Let us examine. In fact, my intention was to close it because every day, lordship, these batches of cases.
Yes. This is what,
But without, because what will happen? My problem is only this, that I have to face this case in the division bench also. This is not the end. So without those facts, whether it will be proper for me to make my submissions in the division bench, because those facts will be relevant. If it is in our favor, will not, but otherwise they will go. They went against the interim order also. Even we went against the interim order also. So it has a bigger and longer ramification. So I do not want to be.
on
forced
what points you want to file the affidavit?
on the that sequence of events. The most crucial part, what they have challenged, they have jumped from the issue of first notification where dates were given regarding the petition of the objections, etc. And sequence like notification. Then the main notification was issued by the government regarding the Gaon Panchayat. The Delimitation Commission issued the notification on 11th of November. What exercise that Delimitation Commission has done on the basis of, because there is a reference of the 15th October's notification in the notification issued on 11th. So what exercise they have done from 15th October till 11th of November by the delimitation, that part is not before this honorable court or before us also. We have to seek instructions. Then on 28th of December, lordship, the electoral roll was published and election commission issued certain further notifications on that on 18th of January, if I'm not wrong, 17th of January. All these things are not before this honorable court. In
But-
fact, it is the duty of the writ petitioners to bring these hard facts which are available in public domain. And our affidavit is basically in response to their cases, what they have pleaded.
Will only confine to this SOP and this 1510. That's all. They have not challenged anything more.
They have not challenged.
So we are not going beyond 1510. Because only challenge is that their
On
prayers.
15th, what is the issue?
Yes.
243C. Let us come to 243C. What is 243C, lordship? Let us
Yes,
see now.
constitution.
Composition of panchayats.
Hmm. Two 43 is the composition of panchayats. Subject to the provisions of this part, the legislature of a state may, by law, make provisions with respect to the composition of panchayats.
provided that the ratio between the population of the territorial area of a panchayat at any level and the number of seats in such panchayat to be filled by election shall, so far as practicable, be the same throughout the state. So if they have to make it, they have to give datas
Hmm.
of the constituencies which they are staying or residing vis-a-vis the data of the other constituencies of the state.
Hmm.
To establish a case under 243C, this is the basic factual matrix they have to place before this honorable court. So I'm I'm not going further. On this point, Lordship, the Supreme Court in state of Uttar Pradesh versus Pradhan Shankhetra Samiti and others,
Hmm.
1995, supplementary volume 2, Supreme Court cases 305, laid down the principle. Paragraph 40,
Paragraph,
40,
okay, 1995.
43.
Supply
Paragraph is also 43, Lord.
to SCC 305 State of UP Pradhan Shang
And book one.
Paragraph,
Paragraph 43.
paragraph 43. Mr. Kaur and Mr. Dubey, can you give me a thing? What are the prayers in all this batch of petition? Prayer portion, just one line, one line. Okay, paragraph 42.
Without touching the these petitions, those NGO petitions. Those prayers we are not handling, Lord. May I read it, Lord? Paragraph
Yes.
43. The High Court has also declared that the provisions of Section 2, Roman 2, read with those of Section 11F, ultra vires the provision of Article 243E. Because according to the High Court, the provisions of the said article require at the first a territorial area should be carved out to make it the panchayat area, and then the population of the area should be adjusted so as to ensure uniform ratio of representation as required in Article 243C. Instead, the provision of Section 2, Roman 2 and 11F carve out the panchayat area on the basis of population alone, and the basis for it is conspicuous by the absence in the act, and this has created confusion. Now, this is the main line. The representation of an area has to be balanced to the ratio of the population in it and not the population of the area. Territorial constituencies are subdivisions of panchayat areas. A densely populated area will automatically contain more seats than a sparsely populated area will contain lesser seats than the densely populated area. Hence, the provisions of the Act are ultra vires the Constitution. We are unable to appreciate the reasoning of the High Court. Article 243E defines panchayat area to mean territorial area of a panchayat, and Article 243C speaks about the composition of panchayats and leave it to the legislature of a state to make provisions with respect to it. The only condition that the latter article imposes on the composition of panchayats are: number one, firstly, the ratio between the population of the territorial area of panchayat at any level and the number of seats in the panchayat to be filled by election, so far as practicable, to be the same throughout the state. Secondly, the seats in the panchayat have to be filled by direct election from the territorial constituencies in a panchayat area. And for this purpose, the panchayat area has to be divided into territorial constituencies in such a manner that the ratio between the population of each constituency and the number of seats allotted to it have, as far as practicable, to be the same throughout the panchayat area. So long as these conditions are complied with, the composition of panchayats that may be evolved by the state legislature cannot be faulted. We do not see any materials before us to suggest that these two criteria are breached so or thought to be breached. So I'm stopping here, Lordship. That the foundation they have to establish. It cannot be a whimsical exercise without doing the proper homework. They cannot actually come to this honorable court and seeking some relief under Article 240, 226.
Hmm.
The foundation they have to establish before is to invoke the provisions and mandate of Article 243C is that they must have proper data, the quantifiable data of their area vis-a-vis the remaining part of the state. Because this provision of 243C draws a comparison between their area and the rest of the area of the state.
Yeah, otherwise in census,
Yes,
village-wise population is also there.
everything is there.
2001 census is the basis.
Basis. So 243 argument goes, Lordship, in my
Hmm,
humble submission.
Okay,
Unless they give us proper foundation with the facts, which we will have a right to refute, that is not done. And the the Constitution also has given the handle that as far as practicable. Therefore, if I take that
Ah.
the while the Election Commission of India had undertaken the delimitation exercise of parliamentary and assembly constituencies in the state of Assam, they have issued certain frameworks.
same.
It is a part of the preface. If Lordship is come to page 3, it's a very bulky chapter, so I am giving the main page. If on affidavit, we could have given everything, Lordship. In any case, page 3.
Hmm.
May I read it, Lordship?
Yes.
While the legal framework is laid down in the Delimitation Act 2002, as well as Section 8 of the RP Act 1950, the actual experience of conducting this exercise was a professional and personal journey for all of us in understanding Assam, which in itself is a representative microscope of India at large. It has the diversity of physical features, ethnicity, religion, challenges of backwardness, aspect of international borders, interstate boundary legacies, youthful aspirations, population, and above all, a rising economic profile. The peculiar geo-landscape of the state presented unique issues arising due to enthusiasm and political aspirations across the state on one hand, and on other hand, sometimes competing political, geo-physical, and cultural factors of different regions like Bodoland Autonomous Hill Districts, Barak Valley, Upper Assam, Lower Assam, and Northern and Central Assam. The vast difference in population density between districts ranging from 13.8 persons per square kilometer in Dima Hasao vis-a-vis 1096 persons per square kilometer in Kamrup Metropolitan District, existence of regions having extremely difficult inter-district connectivity due to the geographical barriers, etc. Thus, it manifests a textbook challenge to any delimitation exercise, that is, the balancing the representative principles with divergent interests of the voters. It very clearly indicates the practical and pragmatic problems which the Delimitation Commission, whether it is under the Election Commission of India or under the state authority. It is very clearly indicated. So we cannot have a mathematical precision while delimiting the Gaon Panchayats, Anchalik Panchayats vis-a-vis the parliamentary constituencies as well as the state legislative assembly constituency. Now coming to another page that will be, if Lordship, it is flag mark 3 pages from the end. It is flag mark. Internal page will be 53, which Lordship can find at the bottom.
Yes.
Division of state into parliamentary and assembly constituencies. The division of state of Assam into assembly and parliamentary constituencies is to be made having regard to the total number of existing seats in the state legislative assembly and the total number of seats as allocated at present to the state in the House of the People. In other words, the state of Assam is to be divided into same number of assembly constituencies as the total number of existing seats in the state legislative assembly, that is 126, and the number of parliamentary constituencies in the state would be equal to the number of seats presently allotted to the state in the House of People, that is 14 per schedule and second schedule. This has not changed. Neither 126 has been changed nor 14 has been changed. In our case also, the number of Gaon Panchayat, etc., all other BRIs, there is no change. That is why that 5-1 notification is absolutely not called.
That is why I am saying, that is why I am trying to understand that panchayat, Gaon panchayats are not changed, number of Gaon panchayats.
Lordship.
But only thing, in this
The boundary,
Sonai LAC people, they are saying that from our 24,
we have
6 have been taken away.
Lord.
And what is the reason behind it? That is what I want to know. And because of this fixing of boundaries by the Election Commission of India, these 6 have been taken away, or by independent exercise of the state.
The thing is that Sonai boundary,
Uh,
there are a lot of constituencies whose names are changed, areas are changed. I can give lot of examples of that.
Only one, we'll taste only one.
Only one. Yes, it was expanded.
No, they are saying, we don't know the reality, 20 from 24, it has been reduced to 18. That is what they are saying.
Number, Lordship, we'll have to take it into the basis that whether Sonai constituency as it was existing earlier, is there any change or not?
Geographically, it has been changed or
It
not.
has been changed.
That is what,
It is as simple, Lordship. It is changed. That is why all these permutation combination, this cosmetic change are to be done now.
that is what I am trying to find out. That 20 from 24 to 18, what is the reason? Because of changes in the geographical boundary. And that necessitated to take away 6 Gaon panchayats out of Sonai. That's all. I have not found the answer. That is why. That is-
Because this was not a legal question, that's why maybe they have not explained.
No,
From them, Lordship.
item number 1, you have filed the affidavit.
Yes.
Initially.
That
that-
affidavit was filed at a very in a hurried manner when there was lot of pressure from the other side.
Okay.
And the court also wanted that file a short affidavit. That
Okay.
was the perception at that point of.
Then from this document, anything?
Further, all constituencies shall, as far as practical, be geographically compact area, and in delimiting them, regard shall have to be the physical features, geographical area, density of population, existing boundaries of administrative units, facilities of communication and public conveniences. In fact, Lordship, if this exercise was when the assembly election was done, assembly delimitation exercise, prior to that, we had created about 4 additional districts. Those districts were not there in the 2001 census or at that point of time. We have to merge those districts before the exercise was undertaken, so that there is no discrepancy. I can give the example. Bojali was taken out from Borpeta, again it was merged. Sunitpur and Vishwanath was bifurcated, then it was merged. Ujai and Nagaon was bifurcated, it was merged. And Tamulpur and Bas. So all this, if we have to go to the depth of this, Lordship,
After
very
LAC,
scientific exercise, very scientific.
after LAC, again districts are,
After that, it has to be done.
Hmm.
Because for administrative reasons, we have to. This is helping the people. Ultimately, the paramount interest is the public interest. Why the districts are created? We are actually making or segregating blocks. What are districts? These are administrative blocks actually. We name it district, we name it subdivision, we name it co-district. Nowadays, that is a new concept. Co-district. So these are helping the people. We have some IS officer, they will be the deputy commissioners tomorrow. When an area is under a deputy commissioner, or we call it district commissioners now. if he has to take care of all land sale permission and all land sale activities, lordship, the whole district comes to him. So the pressure is too much. If we take the example of Kamrup, Kamrup is a very vast district. Boku is about 150 kilometers from Guwahati. That person will also have to come here. The other person who is also staying sometime in the North Guwahati or somewhere else, they will also have to come. If we have segregated the districts, what we have done, we have made Kamrup rural, so that the people from that particular part of area, they will come to Kamrup district, and the other part, which comprises of the Sonapur area, Chandrapur area, they will come to Kamrup metro to make it convenient. Identically, if we take the example of Borpeta, when Bojali is another district, the people from that area can get all their land regulated activities. That is one part. Now, why these PRIs are required? All the finance commission's fund that comes, lordship, it has to go to various schemes of the development of the rural areas. These are basically rural areas development. So when the fund is given to this area, if it is more blocks, more people are involved, and they can look after the activities of those development work in a much more objective and profitable way. Profitable way, I am not using that word for the profit, means for the society. The fund is also allocated. Each population, each person's number is according to the Gaon Panchayat or various PRI institutions. If suppose one of the Gaon Panchayat of Sonai has 1,000 people, the fund will be according, it is pro rata basis, basically. If it has 4,000 people, the fund will be more. If it is 1,000, the fund will be less. So it is a very balanced work which has been done. And for that, lordship, that roving inquiry is absolutely not possible. And why this delimitation commission, sir? Because as lordship said, we cannot go into the details. Like the government also cannot go to the details. Who are the persons who constitute this delimitation commission? 3 persons are identified.
Yes.
May I just look? Section 3. 3A. The government shall constitute in every district a district delimitation commission to decide the size of Gaon Panchayat, Anchalik Panchayat and Jilla Parishad. The district delimitation commission shall consist of the following members: district commissioner, that is the chairman, chief executive commissioner of Jilla Parishad, member secretary, and election officer. So they are the grassroots level officers. They can go into the minor details, whose household will fall into which Gaon Panchayat or which ward. So this is downlining the whole administrative work. The Panchayat and rural development sitting in this board cannot think about what area will be covered by Gaon Panchayat in a constituency in Sonai or in Karimganj, now which is called Sribhumi. So these election commissions, basically what they have noted in their handbook, are very relevant. We have to take a pragmatic view. If you compare our state with Arunachal or other hill states of the northeastern, there is a huge difference of population density. In Arunachal, there are only two Lok Sabha constituencies. Size of Arunachal is much, much bigger than Assam. Why? Because the number of population is less. If Sonai constituency, lordship, in my humble submission, has less area and less population than the neighboring constituency, after the delimitation, it has been narrowed down. We will have to examine and we'll have to place it on record if lordship directs. That why there is a decrease of 12 number of A6 number of Gaon Panchayats in Sonai after the delimitation exercise. We'll come with a very acceptable answer, because this delimitation exercise is done very scientifically. They went when and also lordship will kindly come to that same page, population.
Yes.
Same page. the page which I was referring,
Hmm.
page 53 internal, that flag mark,
Yes,
population Roman 2. May I read both?
yes.
All assembly and parliamentary constituencies in the state are to be delimited on the basis of 2001 census. The census figure of 2001 as published by the Census Commissioner are thus alone to be taken into account for this purpose. For this purpose, the total population of the state 2001 census shall be divided by total number of assembly constituencies in the state, and the state average per assembly constituency shall thus be obtained. This state average shall be the guiding factor for delimiting the constituencies due to huge inter-district variation in certain cases. Here they have noted it, huge inter-district variation. Like NC, that Dima Hasao vis-a-vis Lordship Nagaon. Due to huge inter-district variation in certain cases in terms of factors such as geographical features, density of population, means of communication, public convenience, contiguity of the area, and necessity to avoid breaking of administrative units, and as constituencies cannot be delimited having exactly equal population in all cases, deviation to certain extent from the state and the district average has been allowed. So that is why the constitution frameworks.
Next one
as
was
Lordship.
administrative.
The population to be taken into account is the population of 2001 census. The Election Commission has decided that constituencies shall be delimited having regard to the administrative units, district, development block, panchayat or VDCC, ward, etc., as in existence on 1st January 2023.
So
For
they
Jan-
have gone into the villages. So that is why I am asking. I have read this document.
Lordship. The commission shall in its letter dated 27 December 2022 has already written to the Chief Electoral Officer Assam to take up the matter with the state government not to disturb the administrative unit as its existence on 1st January 2023 till the completion of the delimitation. So these districts were bifurcated after this date. Again, it was merged. That was the reason.
Because they have gone to the village and ward, etc.
Yes.
Gaon Panchayat,
Gaon Panchayat.
this election
So
commission.
this whole
That was a
handbook-
huge exercise.
Yes, this whole handbook is for the purpose of, if Lordship is pleased to come to the first part, first page on the top. Delimitation of parliamentary and assembly constitution of state of Assam.
Right. That is why I am asking that why clause 4.1 you have referred to. Because they have touched wards, panchayats, everything. Right.
Yes, that's
So
from-
if
from-
you have more or less followed it, that is one thing. Or you have deviated from it. Because clause 4.1 is the cornerstone.
In my humble submission, Lordship,
According to your SOP, I am not saying myself. That is why I am asking the question
we
repeatedly.
have to insert only that 4 letters as far as practicable.
Ah.
If we had inserted
Yes,
that,
yes. No, we are
but
not
they have
into,
not- nobody had challenged that SOP. SOP is
nobody has
also not
that
under-
challenge that,
They have
that's
said
it.
violation. but
Violation.
That violation
And
is not.
nobody touches on clause 4.1. They have gone into subsequent clauses, but
Yes.
nobody is touching 4.1. That is why I
It
have,
is not touched and they have not given that reference of this notification. They
right,
have not annexed that document also.
because your SOP is founded on this clause 4.1.
Now, this is a new ground Lordship has developed. They
No, no,
have
no,
just
I am not. I am
No,
not.
no, I'm just
No, if
on
it
a
is,
lighter vein, Lordship, my simple submission, these argument, they could have developed that election commission's notification indicates certain villages also. And there's a diversion from that. This is not their
no,
argument.
no, I have found that they have based entire case on section 5.1.
That notification classification. Please,
This category and they said cell and this cell word and proviso means mandatory, and so state government is duty bound and obligated to issue a notification under section 5.1, which they have not done.
yes.
All right. And this categorization of district is not done. But if we read on on the basis of that, we find that your affidavit says there is no notification for categorization of district. Specific statement in the affidavit, meaning thereby proviso is not followed. Now, if we read section 5(1), it looks like that both should be simultaneous. But on the other hand, you have issued the notification final 5(2).
5(2).
So that is what I am trying to understand. That's all. Because their submission is not
We
telling, because of your statement in the affidavit that there was no categorization of districts. So
It is
it
not-
falls. It falls. So what is the alternative justification for the state? That is what I am trying to find out. That's all.
Our notification is very clearly said 5(2), and we are not saying that that is a wrong citation of the clause. We are sticking to that.
That is why I just once again read.
We-
That's all. I am trying to understand.
That option is always there. And
How do you say it that subsection 2 of section 5? What is your, because
it is very, we are permitted to exclude or include any village.
Hmm.
All these things are given in the second page.
so
After consultation with the Gaon Panchayat, now
Ah.
they have not raised this issue.
no issue.
Why? Because Gaon Panchayat was not in existence.
Right.
That is why they have not raised. So it is not required for us. If we look at the Article 370's argument in the Supreme Court, that National Assembly was no more since 1957.
Hmm.
So that part was not required. We'll put the same argument here.
Okay.
That Article 370's argument.
Which do you have the citation?
But they are not arguing. Let's say, why should they
No, no.
put my cards?
No, I am saying
They have not
if
touched
their
5(2).
entire case of the
Their whole
petitioner,
case is that
5(1).
according to them, maybe I do not know, that first 5(1) has to be followed, then we can go to 5(2). But these are two separate and
that is what I trying to find out.
independent provisions.
Yes, that is what I try to find out.
Dear Lordship. These are it's totally independent provision.
So according to you, 5(2) is independent provision.
Independent provision. So after consultation of Gaon Panchayat, so that is not required because for previous or prior to that notification and this delimitation exercise.
So
of the-
this 1510 is under section 5(2). Okay. So it is an independent one.
Independent one,
Okay, 5(2) is independent of section 5(1).
independent of 5(1). And exclusive and separate clause. To follow 5(2), we don't have to first follow 5(1). That is not
Okay.
required.
Okay,
It is not a corollary.
okay. How do you, what the meaning you ascribe to the by similar notification?
After consultation with the Gaon Panchayat, if it has already been established, the government may by similar notification at any time.
So from there you have drawn the,
Yes, government has the
Oh.
power.
so state can independently
Yes,
follow section 5(2)
5(2),
without resorting to 5(1).
5(1),
Okay,
and it is in respect of Gaon Panchayat.
yes, for Gaon Panchayat. Okay,
We can include within or exclude from
Okay.
village, from any village, any local area or otherwise,
can
from the
follow,
limit of any area. So we can
5(2).
bifurcate the village also.
okay, without resorting. 5(1). Okay, so by this notification, you have indicated villages,
Village.
not, okay, name of Gaon Panchayat. Okay,
Declare that any local area shall cease to be a village and thereupon the
so
local
this
area
is
shall be so excluded
chapter,
from the limit of the village. to all
chapter Roman 4, establishment and constitution of Gaon Panchayat.
Lords.
Okay,
Then 3 is not relevant, Lords. So we have that authority that the government has the issue that notification of 15 October 2024. Number 1, we have the power and there is no challenge to that notification on the ground that government does not have the jurisdiction.
right, it is not.
They have not. So we have that authority, we are competent.
So this first part of subsection 1 of section 5.
Yes, for that I have my arguments,
Uh-huh.
but that is not, that will be an academic discussion. I can I'm well prepared to argue that.
No, no, subsection, one, substantive part of section 5. They are saying that the state government is obligated to issue a notification under subsection 1. That is whole their case.
Yes.
That is of some submission on that.
Now, whether the main part of the provision will prevail or the proviso will prevail, or we have to read both together
Yes.
and make out a workable thing. So for that purpose, also in our affidavit,
Okay. Affidavit.
Lordship is please should take our second affidavit.
Second affidavit.
Assuming that
Uh,
we have issued the
page?
notification under 5.1. That is my caveat.
Okay.
Assuming.
Okay.
So this is purely an academic argument and discussion.
Page 160. Additional affidavit.
Additional affidavit. The second.
Additional affidavit. Additional affidavit in opposition 97. By. Okay. Yes. Paragraph.
Here, paragraph 5.
Paragraph. Paragraph.
And in lot of other cases, Lordship, which are argued, and in this case also, I think 5346, they have not challenged the 24th October notification because that 15th October notification was not common. District wise, constituency wise, separate notifications was issued by the government of Assam. And some notifications were issued on 25th of October also. Those were not challenged. Yes, just for Lordship's clarification.
Ah.
Now, paragraph 205, submission vis-a-vis provision. The deponent submits that section 5.1 proceeds on the
1
premise
minute.
that
I have not got it. Submission vis-a-vis provisions. Okay. Yes.
the deponent submits that section 5.1. Let us first read that provision, Lordship, then I can go to.
Can come back just 5 minutes. Yes, 5.
Lordship, just one more. If Lordship is pleased to take up that SOP once. Page 32 of the petition.
Page 32. Yes.
5346.
Yes.
The EC notification dated 4.1. The ECI notification
Yes.
dated 11th of August 2023 is to be diligently referred to for source of Gaon Panchayat and villages falling in an LSC. We are only concerned about this, Lordship.
This part only. That is what I am.
Yes.
Because you have
Source of-
said source. That you have.
source, the
Ah.
villages.
Ah.
The villages we are taking as a source.
Hmm.
That does not mean that same village cannot go to some other part. So we have to, because the villages are named in that.
Hmm.
So we are taking the reference, but
Hmm.
it does not mean that we have to abide by the geographical area of that village. That part
Hmm.
we are doing now. That is why SOP, if we have, it has to be read
Hmm.
with, there is a, if two villages are merged also, or yes,
Page 60.
here only another thing is there. Gaon Panchayat. So Roman 7, a census village shall not be bifurcated into 2 or more Gaon Panchayats.
Hmm.
So we will not divide a village by two Gram Panchayats. These are the, we have to read it conjointly once we get my submission is that. The source is the villages as indicated there, but the demarcation, etc., are not as per that. The name, the source. Because we need the villages for constitution of the Gram Panchayat. So that is number one, and number two,
For source of Gram
Villages.
Panchayat and villages
Yes.
falling in an LSD.
therefore, if Lordship is pleased to come to page 60, the notification of 15th October.
Yes,
The villages are named.
yes, that is what.
Villages are named.
Huh.
So these villages, Lordship will find in the election commissions.
That is what I am
Will get.
trying
That's
to
a
trying.
connect.
uh,
So the source to give the name of the villages is from that notification.
You may
Now-
rename, that is a different thing.
No, yes, Lordship. And the thing is that this village cannot be bifurcated between two separate Gram Panchayats. So Gram Panchayats will have to be constituted by inducting the villages as per the delimitation commission's decision. That is how we have to take it forward.
Yes, if you read the following clauses, then let us read following clauses of the SOP.
SOP.
Yes,
The number of Gram Panchayats in the district shall remain same as that of the current number of Gram Panchayats in the districts after LSC delimitation. So total Gram Panchayat, if it has 10 Gram Panchayats in the district, 10. 100 means 100.
okay.
So
Then-
that is regarding the Gaon in the village, in the district,
Hmm.
not in the LSC. If it had said that the number of Gaon Panchayats in the LSC shall remain same, then that Sonai's case,
Mm,
they would have been on a very
Mhm.
strong footing.
mm, mm.
So in the district, we cannot increase or decrease the total number of Gaon Panchayats.
So district, they have said in their petition that in the district remain same.
Same, yes,
If I remember correctly,
Yes.
in their pleading, they have said remain same,
yes.
but taken out of LSC.
Yes, now.
that
taken
is
out
what-
of LSC. Now, let us come to another. While the delimitation exercise was done in Assam, so far as assembly is concerned, Lordship, some of the districts have lost two constituencies and some have some additional.
Yes.
Like Golaghat, I think there is a additional. In Karimganj, there is decrease of two LSCs. In
Yes.
Tinsukia, it has been increased.
Mm.
So we have to think it, how it is working. So some LSC constituencies, there will be, in fact.
So
there is change
villages
of-
are not touched.
Villages are not touched. That is why
District wise, Gram Panchayat is same. Number.
That is why this 5-1 was not resorted to.
Okay, let us read the following clauses, you
Yes.
can understand.
Next, one Gaon Panchayat shall belong to only one LSC. That is, no Gaon Panchayat jurisdiction shall be shared with more than one LSC. So that is not the case of any.
Mm, mm.
If a Gaon Panchayat after LSC delimitation is not shared among more than one LSC, then preferably the Gaon Panchayat boundary will be retained.
Again, after the LSC delimitation.
Yes.
So,
If a Gaon Panchayat after the LSC delimitation is not shared among more than one LSC, then preferably Gaon Panchayat boundary will be retained. So,
because that is why I have taken it, you to the Sonai LSC, some
Yes.
Gram Panchayats part. So, next clause.
if a Gaon Panchayat after LSC delimitation is shared among more than one LSC, then the villages under respective LSCs either may be grouped to form a new GP or may accommodate in nearby existing GP provided criteria 4(2) is not violated.
Hmm.
What is 4(2)?
4(2) is number of Gram
Number of
Panchayat in
districts.
district
The
same.
district, it cannot be increased.
6.
6. If a new GP is to be formed without violating criteria 4(2), the population, natural boundary and category of districts shall be considered as per 5(1) of the Panchayat Act 1994.
Some stress is given here.
That category of districts. Now, what is that category? We have to base it on 2001. The district, whatever was constituted and as per that date, 17 December or 17 July 2023. There is no change. Election Commission also agreed to that.
Hmm.
So in that view of the matter,
Hmm.
as because there is no requirement to increase or decrease the number of GPs in a district, so that notification in my humble submission is not required at all.
Okay.
It has no meaningful purpose. And that was deliberated also. It is not that I am saying in the course of argument
No.
here. It was deliberated in the cabinet also and in the administrative level also.
So the spirit is to be followed.
Spirit has been, and we have to follow basically.
So without issuance of any notification.
without this. That is also not required, Lordship.
No, because 5(1) it says
I want says,
spirit is to be followed or what? Because clause 4
Because-
Roman 6.
why I am saying, Lordship,
Yes.
suppose we are changing the total constituencies in every district. Then this spirit or in strict meaning, Lordship, we should have done this. Because the district will, because this proviso says the notification should be in respect of the district,
Hmm.
not in respect of the LSC or other components of the administrative blocks. So the district is intact. So whether the district falls under category A, category B, or category C, it does not have any purposeful meaning. Because we are not going to touch or tinker with the number of GPs in the district. Suppose if district is categorized in C, whether that district will have less number of GPs, or if it is in category A, where the population is more, will that district have more number of GPs? That exercise is not done.
Hmm.
That is not permissible within the parameters which was set for this delimiting exercise. So therefore, this notification, even if it is mentioned in 5(1), in my humble submission, is not required at all because the overall and the main
Okay.
decision which was already set,
Mhm.
that there will be no increase or decrease of GPs in a district. And this particular categorization and this notification contemplated is only under the proviso, not in the main part. That
Okay.
argument I'll develop little bit later.
Roman 7.
Roman 7.
Uh,
A census village shall not be bifurcated into 2 or more Gaon Panchayats.
is it any of the case? No.
None of
No.
their cases.
And Election Commission of India also has not tinkered with any census village, I think.
No,
And you have not also.
we have not.
Okay. Then
As per LSC delimitation, if a Gaon Panchayat is divided into 2 districts, then the Gaon Panchayat will be considered in the district having the Gaon Panchayat headquarter. So that is not the case here. Nobody's case is that. No Gaon Panchayat is being shared by 2 districts.
okay. 4,
9.
8. Nobody's, I'll not read all the repetitions. Nobody's case. Nobody's case.
4-8, no.
4-8, nobody's case. Okay. No,
Yes, you may note it down.
that is making my task easier.
Now,
Yes.
next 9.
Hmm.
After delimitation of Gaon Panchayats, the delimitation of Gaon Panchayat constituencies, that is 10 number of wards within the Gaon Panchayat shall be done as per 6(2) of the Assam Panchayat Act 1960.
Show me any notification 6(2).
We have that. 11,
Where is
11.
that? Any
11.
part? Somewhere it is there. I have seen somewhere.
I have given Lordship. We can, this morning I have given.
Ah,
Oh. It is issued under 6(2). 11.
gazetted.
Gazette or not gazette.
Let us see last part.
The first part, Lordship, the very beginning. In exercise of power conferred under subsection 2 of section 6
Hmm.
of the Assam Panchayat Act 1994 with sub-rule 2 of rule 6 of the Panchayat Act rules 1995. and in pursuance of the government notification of 15th October 2024,
Hmm.
the following Gaon Panchayats, wards under Gaon Panchayats of Badarpur, Satyendranagar, Anchalik Panchayat, and Karimganj Jilla Parishad are hereby notified. So wards are also notified along with the. And last part, if Lordship is pleased to look at. The last part, there is no last part on the district commissioners and chairman's signature.
Ah.
So
For kind
we have
inform-
complied that also.
Okay.
6.2 is also complied. Duly
Now,
complied.
now the contentious clause, they are
Yes.
relying
The
upon.
categorization of district based on population density and other relevant factors will be followed as per sections here. So
This one,
it
they
is,
are,
it is in the SOP.
Ah.
It can remain in the SOP.
okay.
Whether that is required or not required. That is why the addendum is also issued. And from the records, Lordship will have to
And-
see. These are not statutory provisions. This SOP, Lordship, is
Okay.
number one, not in challenge, and number two, it does not have the value or strength of any
SOP
statutory provision.
410 is not statutory provision.
Yes. And this is a guideline. If I'm not wrong.
Guideline, yes.
Basically, it is a guideline. So that there is some uniformity in the delimiting exercise throughout the state.
Hmm.
Because some districts, there are 35 district commissioners who will be manning or who will be at the helm of affairs in this district delimitation commission.
Hmm.
So everybody will have different ways of working.
Hmm.
As we have seen in education department, each officer comes, different system he evolves. Finally, we have to have some statutory
Hmm.
rules and regulations. Otherwise, this administrative notifications under Article 162 are really creating sometimes problem.
So,
So
Purana,
this 10, although it is inserted, the categorization of district on based on population, there are other relevant factors will be followed as per section 5.1 of the Assam Panchayat Act. Now,
Ish-
5.1, what does 5.1 says?
Hmm.
5.1, may I read it, Lordship?
Yes.
Establishment of Gaon Panchayat. The state government may by notification declare any local area comprising a revenue village or a group of revenue village or forest area or tea garden area or hamlets forming part of revenue village or forest area or tea garden area or other administrative units or part thereof to be a Gaon Panchayat with population of its territory as per the category within which the district falls. Provided that the state government shall declare 3 categories of district based on population density or any other relevant factors as follows. Category A, district shall be higher population density, shall have Gaon Panchayat with population ranging from 10,200 to 13,800. Category B, district have medium population density, shall have the Gaon Panchayat with a population range from 8,500 to 11,500. And category C, have lower population of density having the Gaon Panchayat with a population ranging from 6,000 to 9,200. So this is the provision, Lordship.
Hmm.
Here, the government, the state government has the power to issue notification regarding constitution of the Gaon Panchayat based on population of its territory as per the category within which the district falls. So district wise, they have to say.
Hmm.
Now, the decision is already taken that there will be no change of the number of Gaon Panchayats or any other Panchayati Raj institution units in that district. So we need not go to the second part. Number one, our whole basis is to get the population quantum was from the 2001 census.
Maybe it is a foresighted thing,
That is why
2026,
the will word is there. Will.
2026 when it will come.
That is why Lordship, if Lordship is pleased to look at the SOP.
SOP.
SOP also says the categorization of district of population density and other will be followed as per section. So here also it is a future tense.
Okay.
Otherwise, it will have been said that it is already there, you follow, or you first issue this, then you carry out the exercise.
Hmm.
And it does not have a statutory force, Lordship. Lordship, you
Yes.
see whether we have violated the provisions of Panchayat Act
Yes.
rules vis-a-vis the Constitution of India.
That's all.
Just like our transfer guidelines, it has no statutory or enforceable right can be accrued on the basis of this kind of guidelines.
Hmm.
This is a working system which was developed by the state of Assam. We do not find SOPs anywhere in the rules or the
Yes.
act. So now, on this point, Lordship, my legal argument will be,
Yes.
what will bear? Which will prevail?
Hmm.
The main component of the provision of the act section or the proviso? The section 5 says the state government may by notification. Lordship will kindly mark this word may.
Hmm.
Declare any local area comprising a revenue village or a group of revenue village or forest area or tea garden area or hamlet forming part of revenue or forest village or tea garden area or other administrative units or part thereof to be a Gaon Panchayat with population of its territory as per the category within which the district falls. So the notification may be issued by the government under section 5 is on the basis a Gaon Panchayat is constituted on the basis of population of its territory as per the category in which the district falls. Proviso says the state government shall declare 3 categories of district based on the population. So when the state government issues a notification declaring 3 different categories of districts, then the notification which is contemplated under 5(1) will carry the population of the territory as per the category. That Gaon Panchayat so and so in district so and so, which is in category so and so with a population of so and so. That would have been the notification language. That is not there. Our language is very simple. Where is our notification? Let us see, Lordship. 15 October notification. 15 October notification, the language is
Yes.
in exercise issued by the Panchayat and Rural Development Department, the government, not the delimitation commission. In exercise of the power conferred under subsection 2 of section 5. Lordship may highlight this. Of the Assam Panchayat Act 1994 and in pursuance of the cabinet decision taken in its meeting held on 8th October 2024, the governor of Assam is pleased to notify the following Gaon Panchayats along with their corresponding villages of Kachar district in such and such Gaon Panchayats and the villages. So this is the way the exercise was carried forward, and after this, on the basis of this notification, the subsequent notification of the words under section 6(2) was also issued by the District Delimitation Commission. And the District Delimitation Commission, it has been not prescribed under the act that the government will issue. The word is used there in 6(2) is the prescribed authority.
Mhm.
That is the prescribed authority as per the SOP and etc. Lordship. It is the District Delimitation Commission, not the government.
So your submission is that this may and shall appearing in subsection 1 and in the proviso, if a notification under subsection 1
Yes.
of section 5 is to be issued constituting a Gaon Panchayat, then it will follow this categorization. But here in the case, it is the notification is not issued
Under 5(1).
5(1), so this categorization is also not necessary.
Yes.
On the other hand, government has chosen to exercise its power under subsection
Yes,
Two.
Yes,
subsection 2.
which is a totally independent provision in the
Independent.
statute.
Okay.
And their case is totally silent that
Right.
we have exercised power under 5.2, but there also we need to have a notification under 5.1. That is not their case. Their case is that for any kind of notification for composition of the Gaon Panchayat Lordship, a categorization notification is to be preceded.
Sign one on.
So I would like to take 3-4 judgments on this point also.
Yes.
One is that Privy Council Page 544 of the Privy Council case. Thompson versus Diblin. But all these cases were very elaborately described in Adani's case, which I'll place
Okay.
little bit later. The foundations were from this Privy Council, and subsequently the Supreme Court also developed this law of interpretation.
Yes.
May I read it?
Yes. Which part?
March, page 554, the second paragraph.
554.
4, the judgment of the House of Lords.
Page 554.
54. 544.
Oh, 544.
Sorry, yes, 550, 544. I'm sorry,
540.
44. First, the second paragraph it starts. Much, if not the main, reliance has been placed by the Appellant's Council on the first proviso to section 1. I do not think that the argument founded on it is well founded. It is opposed to the settled rule of construction that a proviso must prima facie be read and considered in relation to the principal matter to which it is proviso. That is the marriage contract. It is not a separate and independent enactment. The words are independent on the principal enacting word to which they are tackled as a proviso. They cannot be read as divorced from their context. So here our case is very simple, Lordship. The context is that we are not changing the number of constituencies in the number of Gaon Panchayats in the district. And in that view of the matter, as there is no change of the numbers of GPs, there is no requirement for this. On top of that, the notification which is contemplated in the main act of section 5.1. Here also the government has used the word may by notification we can issue. But the second part is not coming under the main provision. If the first part was taken as a part of the main act, main provision, Lordship, that proviso part, the things would have been different.
Last part, the substantive part of the provision. With population of its territory as per the category within which the district falls.
Yes.
So it is concomitant, but categorization is to be.
Now, so far as the present exercise is concerned, Lordship,
You are not issuing any
have
notification.
any relevance.
Okay, you are not issuing any notification. That
We
is
are
your
not
case.
issuing because we have to base our whole exercise on 2001 census. The district as is existed before 17th July of 2023. So nothing has changed here.
Okay.
So there is no objective other than a futile formality. It will carry nothing.
So case of the both sides are completely different. They are on 5.1, you are on 5.2.
That is why now we have to give the reply as
Yes.
per the
Yes.
pleaded case.
Yes.
The pleaded case is totally on a wrong footing.
Okay.
They have not seen the proviso on the basis of which the notification of 15th October was issued. If they had not done that exercise also, no due diligence was done, everybody will get confused and get misled. This election could have been held in the month of January. This election would have been, we have missed the bus. The people of Assam in those districts, because of few 9 writ petitions, everything got topsy-turvy. Why? Because Their whole case is based on 5-1 and our case is 5-2. And the Honorable Court at one point of time restricted us from conducting the election. Had it been issued, had we got that green signal on 10th of January, same day we'd have issued the notification, but 12th of January, there was a difficulty. I think on 12th, that was a Sunday, we got that order uploaded. 13th January, we could have issued the notification, but we need minimum 30 days from the notification to start the process. The process will start with the notification, but the holding of voting, etc. All our matriculation and higher secondary examinations were scheduled from 13th February from HSLC and 15th February the HSLC. Because of that, till today we have not issued. Now we have got the green signal from the division bench that we can go ahead. But the ground reality, we have to see where that polling will take place. We have to use the schools.
Okay,
We have to, that is why waiting
Mhm.
till 27th or 20, when all the examinations will be over. Thereafter, we are going to issue the notification
when the examination will be over?
in a day or two, Lordship.
Okay,
The ball is set now.
Hmm.
If nothing is there, Lordship, then on 2nd of April, we are going to issue the notice. We are not hiding anything from this Honorable Court and from the other side also. In fact, on the last occasion, I made this statement.
any,
And when I saw some Facebook updates yesterday in the social media that a notification was to be issued by the concerned minister day before yesterday. I got shocked because I made a statement, I verified. So that was a fake update in the social media. With his face, with date, I do not know who has done this mischief. How they are trying to influence the court or to the general public, we do not know, Lordship. There are a lot of confusions everywhere. And we are slowly running away from the hard facts and the ground reality.
okay, next.
I was really confused because I made a statement. When I am not as a person, but my position, if
Mhm.
the statement is made, if it is changed, Lordship, then that will give a wrong impression. And people will, the Honorable Court will start disbelieving the government councils.
Yes. Okay,
Now,
Privy
next one.
Council, then,
Dwarka Saraf, Dwarka Prasad versus Dwarka Saraf, 1976, 1 SCC, page 128. Page 128,
1970.
paragraph 18.
1 minute, 1970. 128. Dwarka.
Paragraph 18, Lordship.
Prasad, Pera,
18.
18.
We may mention in fairness to council that the following among other decisions were cited at the bar bearing on the use of proviso in statutes. CIT versus so and so, even this Privy Council case is also mentioned. The law is right. A proviso must be limited to the subject matter of the enacting clause. It is a settled rule of construction that a proviso must prima facie be read and considered in relation to the principal matter to which it is a proviso. It is not a separate and independent enactment. Words are dependent on the principal enacting word to which they are tagged as a proviso. They cannot be read as divorced from their context. If the rule of construction is that prima facie a proviso should be limited in its operation to the subject matter of the enacting clause, the stand we have taken is sound. To expand the enacting clause inflated by the proviso seems against the fundamental rule of construction that a proviso must be considered in relation to the principal matter to which it stands as a proviso. A proviso ordinarily is but a proviso, although the golden rule is to read the whole section, inclusive of the section of the proviso in such manner that they mutually throw light on each other and result in a harmonious construction. The proper course is to apply the broad general rule of construction, which is that a section of or enactment must be construed as a whole, each portion throwing light, if need be, on the rest. The true principle undoubtedly is that the sound interpretation and meaning of the statute on a view of the enacting clause, saving clause, and proviso taken and construed together is to prevail. So I'm going to the next judgment. Lordship. This is the principle here. And the elaborated version is that Adani's case, Lordship. Adani Gas Limited versus Union of India, 2022, 5 SCC, page 210. Hmm? No? Move it up to one. Move on this.
Para,
Lordship, I am coming back. Para 68, then 69 to 70 to 75.
68, 69,
69, it's like 68 to 72 and 75.
68 to 72 and 75.
I'll place this judgment and raise judgments. I'll just give the reference. I'll not place. 68. At this stage, it would be necessary. Have lots got it.
Yes.
Paragraph 68. At this stage, it would be necessary to notice the scope of a proviso. Proviso ordinarily carves out a field of operation, but does not travel beyond the main enacted provision. Therefore, the golden rule of interpretation is to read the whole section inclusive of the proviso in such a manner that they mutually throw light on each other and result in harmonious construction. This was held in Dwarka Prasad and Dwarka Das Saraf. If we may mention in fairness to counsel that the following, among others, were to cite at the bar bearing the uses of proviso in statute. In CIT versus.
This you have read.
This you have read, Lordship,
Ah,
69.
Dwarka, yes.
What I am trying to emphasize, in the main part, Lordship, the word is may. That government may issue a notification by issuing a classification notification also. It has the option. If we, without that also we can do. That is what I am trying to emphasize. If the main part of the act says the state government may by notification, that means that notification may include that classification status or not, or otherwise also we can do it. We cannot follow the dictate of the proviso. Because here, if the legislator used the word shall at top, things would have been different. But here it is may.
Okay.
That optional thing is there. We cannot read may as shall here. Now, paragraph 69.
Yes.
Later in Sundaram Pillai versus so-and-so, this court held as follows. The well-settled rule of interpretation of a proviso is that a proviso may have three separate functions. Normally, a proviso is meant to be exception to something within the main enactment or to qualify something enacted therein, which but for the proviso would be within the purview of the enactment. In other words, a proviso cannot be torn apart from the main enactment, nor it can be used to nullify or set aside at naught the real object of the main enactment. Price in his statute book has, while explaining the purpose and import of a proviso, states in so-and-so, the effect of an accepting or qualifying proviso according to the ordinary rule of construction is to accept out of the preceding portion of the enactment or to qualify something enacted therein, which but for the proviso would be within it. The natural presumption is that for the proviso, the enacting part of the section would have included the subject matter of the proviso. We are skipping this. Now coming to paragraph 70. Let us go to 72. In the principle of statutory interpretation, GP Singh's edition, in interpreting a proviso creating a legal fiction, the court is to ascertain for what purpose the fiction is created. In Cochin, etc., these judgments are taken. And after ascertaining this, the court is to assume that all those facts and consequences which are incidental or inevitable corollaries to the giving effect to the fiction in so and so case, etc. But in so construing the fiction, it is not to be extended beyond the purpose for which it is created in Bengal immunities case, etc. Or beyond the language of a section by which it is created. It cannot be extended by importing another fiction. The principles stated above are well settled. A legal fiction may also be interpreted narrowly to make the statute workable. This is one way of my enforcing my argument, Lordship, that as districts are not going to be changed, the number of GPs within the districts are not going to be changed. This whole exercise is not required. Therefore, it is for the working purpose also. The proviso part can be skipped or avoided. The distinction between the central authorities and the, sorry, I mean, this is the particular case. Now coming to paragraph 75. In superintendent and remembrances of legal affairs versus Abani Meiti, this court observed as follows. Exposition ex specificis actus is a long recognized rule of construction. Word in a statute often take their meaning from the context of the statute as a whole. They are therefore not to be construed in isolation. For instance, the word of the word may would normally indicate that the provisions are not mandatory, but in the context of a particular statute, this word may connote a legislative imperative, particularly when its construction is in a permissible sense, would relegate it to the unenviable position, as it were, of an ineffectual angel beating its wing in a luminous void in vain. If the choice is between two interpretations, said Viscount, the narrower of which would fail to achieve the manifest purpose of the legislation, we should avoid a construction which would reduce the legislation to futility and would rather accept the bolder construction based on the view that Parliament would legislate only for the purpose of bringing about such effective results. Now coming to the other concept, that the difference between may and shall in a statute. For this purpose, Lordship, I am relying upon three judgments. 1961, 1961 SCC online page 5434, paragraph 16.
Nineteen SCC 9 SA 34 P class. Joint Korea. Yes, para.
Yeah.
Para.
Paragraph 16, Lordship. The question still remains. Lordship.
Yes.
The question still remains whether the purchase orders executed by the divisional superintendent but were not expressed to be made by the Governor General and were not executed on behalf of the Governor General were binding on the Government of India. Section 175(3) plainly requires that contracts on behalf of the Government of India shall be executed in the form prescribed thereby, and the section does not set out the consequences of non-compliance. Where a statute requires that a thing shall be done in a prescribed manner or form but does not set out the consequences of non-compliance, the question whether the provision was mandatory or directory has to be adjusted in the light of the intention of the legislature as disclosed by the object the purpose and scope of the statute. If the statute is mandatory, the thing done not in the manner in the form prescribed can have no effect or validity. If it is directory, penalty may be incurred for the non-compliance. But the act of or things done in regard as good, as observed in Maxwell in the interpretation of statute, it has been said that no rule can be laid down for determining whether the command is to be considered as a mere direction or instructions involving no invalidating consequence in this regard or as imperative with an implied nullification for disobedience beyond the fundamental ones that it depends on the scope and objects of the enactment. It may perhaps be found generally correct to say that nullification is the natural and usual consequence of disobedience, but the question is the main governed by consideration of convenience and justice, when that results would involve general inconvenience or injustice to innocent people or advantage to those guilty of the neglect without promoting the real aim and object of the enactment. Such an intention is to be attributed to the legislature. The whole scope and purpose of the statute and the condition must be regarded. Pausing here for a moment, Lordship. The Act very clearly says that the government has the option of issuing a notification under 5(1). And that notification, it has been said that may issue that notification with the mentioning of the area of the Gaon Panchayat with specific mention about the population within its territory. If it is not done, what will be the consequence? We have not done it under 5(1). Will a Gaon Panchayat notification issued under 5(2) will cease to exist? That is not the case. If we look at 5(1), 5(2), or else the whole Act, Lordship, there is no indication, there is no intention of the legislature to indicate that first you have to follow 5(1), 5(1) proviso, then you can proceed to 5(2). The language of 5(2) also says, after consultation with the Gaon Panchayat, if it has already been established, the government may by similar notification at any time issue a notification for composition of a or constitution of a Gaon Panchayat. Here, all the Gaon Panchayats are already in existence. They are already in existence. Had it been a case of when after the 73rd Amendment, all these institutions came into force.
Yes.
If at that point of time 5(2) was resorted, then it would have been flawed. Because after the 73rd Amendment, 243 insertion, Panchayat Act came in 1994, then these institutions have come into existence. Decentralization of power, power to the people, power to the grassroots, all these things, concepts developed after that 73rd Amendment, Lordship. At that point of time, there was no existence of Gaon Panchayat. Now we are resorting to 5(2). From last 20, 30 or 3 decades, Lordship, there are existence of Gaon Panchayats in Assam, Jilla Parishad, as well as Anchalik Panchayat. All these PRI institutes are there, like the ULBs also, the urban institutes, urban local bodies, urban local institutes. Lordship. So when we are resorting to 2, the Gaon Panchayats are already in existence. We can tinker with their area on the basis of an exercise to be done under the Assam Panchayat Act, the SOP issued on the basis of Election Commission's source also. So this part, even if we say that 5(1), the whole section is not mandatory, that option we have. Within that section, we have another option. We can issue a notification by mentioning the category of districts or not. We have that option also, and without that also we can do it. Without that also, we can issue a notification under 5.1 simply by saying that this is the area which covers a particular Gaon Panchayat. We can skip the second part, the proviso part also.
There,
Because-
first part is, you see, there is slightly. First part, last few words. It is with a condition as per the category.
Within which, so as per the category, as may not per the category also, because the word is there may at top. That is why I am saying that two options are there. We are stretching it, Lordship.
But there is no notification.
There is no notification. That is why this
Mhm.
exercise is an academic
Ah,
discussion.
This
I am
part,
submitting at the very beginning.
Hmm.
Assuming my opening statement, so far as this argument is concerned, assuming that the notification was issued under 5.1, then these arguments will follow. But all these arguments are absolutely not required in my humble submission because
Hmm.
we have taken
Hmm.
recourse to 5.2. Now I am referring to another judgment or something. 1970 no SCC online. They put a date certificate. Have lordship got it 1900 and 1917 Supreme Court online Privy Council 3.
one PB council.
The second I have given another. Paragraph 206. Paragraph 6. May I start?
Paragraph 6.
Paragraph 6. Party's name, lordship. Montreal Street Railways Company versus Normandin.
Yes, paragraph 6.
It is necessary to consider the principles which have adopted in construing statutes of this character and the authorities so far as there are any on the particular question arising there. The question whether a provision in a statute are directive or imperative are very frequently arising in this country, but it has been said that no general rule can be laid down, and that in every case the object of the statute must be looked at. The cases on the subject will be found collected in so and so pages. When the provisions of a statute relate to performance of a public duty, and the case is such that to hold null and void acts done in neglect of this duty would work serious general inconvenience or injustice to persons who have no control over those entrusted with the duty, and at the same time would not promote the main objective of the legislature. It has been the practice to hold such provisions to be directory only. The neglect to them, though punishable, not affecting the validity of the acts done. This principle has been applied to the provisions for holding sessions at a particular times and places, to the provisions as to the rates, to the provisions to the ballot act, and to justices acting without having taken to the prescribed vote, whose acts are not to be held valid in case now before the vote. This is a factual purpose. So what I am trying to emphasize from this ratio is that when a particular act is not done and it has not created any prejudice or inconvenience to the other, and also it has not followed by any punishment for the omission, lordship, then it is considered to be a directory one, not a mandatory one. Here, suppose this status is not issued, suppose let us assume that we should have it is mandatory on the part of the state government to issue the notification for classification of the districts. How they are prejudiced? They falls under whatever category. I have said in the morning, why these PRI institutions are in place, so that there is good governance at the lowest level, at the panchayati level, as mandated by the constitution. All the good schemes, all the beneficial schemes, the benefits should go to the people living therein. All the activities, be it administrative or otherwise, lordship, it has to be done in a user-friendly or in a convenient way. The funding from the Finance Commission is also coming and distributed within the Gaon Panchayat lordship as per the total number of population. In that situation, whether a particular writ petitioner, whether he falls into category A, category B, or category C, how does it make any difference to his existence? He has a right to vote. He will get an opportunity to vote. He has a right to elect. He is getting a right to elect. If he want to participate in the election, he can participate in any Gaon Panchayat, Ancholik Panchayat, Jilla Parishad, whatever way he wants to participate and be a part of the action lordship, he is open to that. There is no restriction. He has right to vote. He has right to get elected. He has right to get all the benefits of the schemes, beneficial scheme. He can take advantage of all the administrative activities. So this classification of village or not non-classification of village or district, not village, the district, has no effect in his activities so far as in the field of politics, in the field of social activities, or in the field of administrative activities, or in the field of electoral practices. He is nowhere prejudiced. By not doing that, how there can be any attribution of any flow on the part of the state government or the state authorities or instrumentalities? Lordship, we are coming to 1 o'clock.
Okay.
My only humble submission, Lordship, today I am tied up in the afternoon. So could it be taken up some other day? I have lot of other points to argue because they have argued on 8
When to
points.
close also, so that
I want to close
I can finish
but
it before
if
Bihu.
It will go to the appeal, then I will not be able to.
Before Bihu, I want to finish.
Before dinner, let it be on 3rd or 4th on a hearing day, next Tuesday or next Thursday, Lord. On that day, I will complete. Maybe 1 hour more, but they have 8 points of arguments, major arguments, which I have not dealt with till now. On 3rd, that is, I think, the Thursday, no?
Can it be first?
Thursday. On that day, I will complete.
First day, 1st of April?
1st of April. It is a Tuesday, Lord.
Tuesday.
Lot of other cases were fixed, Lordship.
No, I want to
Some
finish this.
outstation Lordship is not.
No. If it is convenient, we can finish in the second half.
In
Or
fact,
first
that
or whatever.
Tuesday, I was checking, Lordship. That Tuesday, I'm totally engrossed in the encounter matter and 2 other important matters in court number 1. And the encounter matter, I think the outstation council is also involved. Lordship may place it on 2nd, on 1st. If any inconvenience, then on 3rd. That liberty may be given to me. I'll try to do it also.
My lord, I have a small sample admission. Yes, my learned friend has clearly said that election will be notified on 2nd. So after being notified, your
Mr. Talukdar, one thing is clear, this court at this stage, because you have not challenged the division bench judgment. Division bench order passed in all those appeals.
yes, ma'am.
What does it say?
Yes, ma'am.
So we'll close it on 1 or 3rd.
My lord, all the time, my learned friend is given enough time, long time on every occasion. And every occasion it was not closed, my lord. It was not completed. Even all the time, and we are always saying that we are anxious regarding the notification. Your lordship will come under some restrictions, my lord, to give any relief we have prayed for, my lord. It will remain mostly as a academic purpose only, my lord.
It would have, I would have been happier if you close tomorrow. I had 3 days holiday. I have nothing to do.
Yes, my lord, that can be done.
It's difficult. Tomorrow is Friday.
Second half,
Then,
I can.
a series, 48 cases series is going on. Tomorrow again, I have to continue. I continued yesterday, day before also.
My lord, this case is also
Yes,
very
Friday-
important, my lord, for the entire state, man. It is also affecting the entire area, man. They are very important also, my lord.
Because
For my learned
I would
education.
have been,
I
I
am in
could
the
have-
mix of 3-4 series matters.
because if it is
In fact,
tomorrow, I
wanted
could.
that case to be taken on Monday, but the other side was out, objecting, so let it be on Friday. Today I could not take it because of this matter.
Tomorrow not possible.
That matter is there. Yes. Friday totally packed tomorrow also.
Okay, Tuesday then,
Tuesday.
My lord, second.
1st of April,
Oh, my lord, first.
1st of April.
My lord, first.
First of April?
Would be difficult, my lord,
Oh,
for everybody. Suppose
not for the court,
even for the court, my lord. Suppose
not for the court.
suppose the Eid is declared on first.
Yes.
That is the reason.
Let it be on
Then,
third.
that is a different thing.
Because
Then
Let it be
that
on
will,
third, Lord.
Because it's as
Lordship,
worship
we
is aware,
have,
my lord.
that is a
the-
very important thing because it depends upon the
Yes.
sighting of the moon.
Yes, my lord.
if it is declared, then it will be listed on 2nd.
Second.
We'll do it in the second half.
Let it be at,
Third.
let us not take any risks. Let it be on second itself. No problem. At 2 o'clock. That's a motion there. At 2 o'clock, also may please to fix. What you my friend is objecting.
No, election office kering. Election.
Put it on first. We'll put the instruction to the racer. If it is declared holiday, on 2nd.
As
And
you-
if possible-
I am open for first,
Huh.
second, third.
First, let us see if it is declared to be holiday, then it is to be listed on 2nd. Let us also close. We don't know. Are you sure about 1st of April?
Nobody is in the side of the.
Yes.
But if it is 31st also, my lord, also the,
31st, I am not coming
No, no,
because
no.
it is holiday.
suppose the Eid is on 31st, it's still difficult for on first month.
Yes. They go to their native place.
Yes, everybody will be in a native place, so that kind consideration that.
Then this will be at your request.
Arre bhai, when do you want? First, let it be first, my lord.
First,
Election declared on
I
second.
am
He's saying.
open.
openly saying that
First,
it's
second, third. Only second half and tomorrow I am.
Okay.
He's saying it will be declared on second.
heart ready hoike Learned Advocate General,
Election will be declared.
Assam for the state respondents. Mr. Soikia has
First of all,
not concluded his submissions and has submitted it. He will conclude his submissions on the next date of hearing. Post of councils who are present, for the for the petitioner side are present. Post of has agreed to by the Learned Council for the parties, list the cases on Tuesday, 1st of April.
My lord, subject to my lord, our.
Subject to
Our submission will be recorded that we are anxious about the declaration of election. He's, my lord, Learned Advocate said clearly on second will be declared. So, my lord,
you make an application.
my lord,
I'll do
submission
that.
may kindly be recorded, my lord.
Learned Standing Council. Assam State Election Commission is present. So actually, I am workless now. I am no cases.
Netflix is there. Lord.
My room is not No network. No network in inside my room. I don't know for what.
This cable, OFC cable connection have to be taken.
My lord,
That's why I'm always saying, Lordship, we have to go to North Guwahati.
one matter is left out, so that.
Better network
Who's
connection will
better?
be there.
7061, but.
No, we are not including any other matter.
Then my lord, it is fixed on first, my lord.
First,
First, my lord, second half or
we'll
first half?
we'll put an instruction, huh?
This first half was 8-2, my lord.
No, we'll say we'll keep it free. We'll conclude. If this first is not declared to be a holiday,
Yes.
and it is declared to be a holiday, then on Wednesday, the second half. Because motion matters would be there, right?
Keep them.
And this is the understanding.